Welcome to a special NatSecMedia presentation of the United States versus Donald John Trump, the special counsel for the United States Department of Justice since 2022, filing by Jack Smith titled, Government's Motion for Immunity Determinations. Submitted to the court on October 2, 2024. The 165-page filing answers the questions created by the Supreme Court, ruling on presidential powers and official acts. As you will hear, the special counsel demonstrates these crimes were not official acts. Take the time to explore each section and consider the overwhelming evidence against the former president, now convicted felon, and his associates. Thank you for listening. NatSecMedia is non-commercial programming supported directly by our listeners and viewers. This is the special counsel for the United States Department of Justice Jack Smith's filing, titled, Government's Motion for Immunity Determinations.
Thank you for watching. In our next segment, we will look at Trump's effort to alter the state electors in Section C.
Section 1. Factual proffer. C. The defendant aimed deceit at the targeted states to alter their ascertainment and appointment of electors.
Shortly after Election Day, the defendant began to target the electoral process at the state level by attempting to deceive state officials and to prevent or overturn the legitimate ascertainment and appointment of Biden's electors. As president, the defendant had no official responsibilities related to the state's administration of the election or the appointment of their electors, and instead contacted state officials in his capacity as a candidate. Tellingly, the defendant contacted only state officials who were in his political party and were his political supporters, and only in states he had lost. The defendant's attempts to use deceit to target the state's electoral process played out in Arizona, Georgia, Michigan, Nevada, Pennsylvania, and Wisconsin, as well as across these and other states that used certain voting machines. In addition to the following evidence of the defendant's conduct during the charged conspiracies at trial, the government will elicit testimony from election officials from the targeted states to establish the objective falsity and, often, impossibility of the defendant's fraud claims. Notably, although these election officials would have been the best sources of information to determine whether there was any merit to specific allegations of election fraud in their states, the defendant never contacted any of them to ask.
1. Arizona.
The defendant was on notice that there was no evidence of widespread election fraud in Arizona within a week of the election. On November 9, 2020, for instance, 2 days after news networks projected that Biden had won, the defendant called Arizona Governor Doug Ducey to ask him what was happening at the state level with the presidential vote count in Arizona. Although Fox News had projected that Biden had won the state, several other news outlets, including ABC, NBC, CNN, and the New York Times, had not yet made a projection. Ducey walked the defendant through the margins and the votes remaining to be counted, which were primarily from Pima County, which favored Biden, and Maricopa County, which was split. Ducey described the situation to the defendant as the 9th inning, 2 outs, and the defendant was several runs down. The defendant also raised claims of election fraud, and Ducey asked the defendant to send him supporting evidence. Although the defendant said he would, stating, "We're packaging it up," he never did. Shortly thereafter, on November 13th, campaign manager Bill Stepien told the defendant directly that a false fraud claim, that a substantial number of non-citizens had voted in Arizona, was false. The same day, as noted previously, campaign attorneys conceded in court that the remaining election lawsuit in Arizona was moot. The defendant and Rudy Giuliani continued to try to influence Ducey. For example, Giuliani tried to contact Ducey on November 22nd, the same day the defendant and Giuliani reached out to the Arizona Speaker of the House, as described below. And on November 30th, the day Ducey signed the Arizona Certificate of Ascertainment formally declaring Biden's electors as the legitimate electors for Arizona, Ducey received a call from the defendant and Pence. Ducey advised them that Arizona had certified the election. When the defendant brought up fraud claims, Ducey, eager to see the evidence again, asked the defendant to provide it, but the defendant never did. Instead, later that evening, and into the following morning, the defendant repeatedly publicly attacked Ducey, as well as Georgia Governor Brian Kemp, on Twitter, retweeting posts by others, such as, "Who needs Democrats when you have Republicans like Brian Kemp and Doug Ducey? Watching the Arizona hearings and then watching Governor Ducey sign those papers, why bother voting for Republicans if what you get is Ducey and Kemp?" Brian Kemp, "My state ran the most corrupt election in American history. Ducey, hold my beer." And why is Ducey still pretending he's a member of the Republican Party after he just certified fraudulent election results in Arizona that disenfranchised millions of Republicans? The defendant and co-conspirators also attempted to use false fraud claims to convince political allies in the Arizona state legislature to ignore the popular vote and appoint illegitimate electors. On November 22nd, the defendant and Giuliani called Rusty Bowers, the Speaker of the Arizona House of Representatives. Giuliani did most of the talking. During the call, the defendant and Giuliani levied multiple false fraud claims, including of non-citizen, non-resident, and dead voters that affected the defendant's race, and asked Bowers to use them as a basis to call the state legislature into session to replace Arizona's legitimate electors with illegitimate ones for the defendant. When Bowers voiced his deep skepticism, Giuliani said, "Well, you know, we're all kind of Republicans and we need to be working together." Bowers refused and asked Giuliani to provide evidence supporting his fraud claims. Giuliani never did. Indeed, Giuliani met with Bowers in person approximately a week later and still had nothing to back up his claims. On November 30th, Giuliani, Jenna Ellis, and others arrived in Arizona for a hotel hearing, an unofficial meeting with Republican legislators, during which they promoted false fraud allegations. In a meeting the day after the hearing, when state legislators pressed Giuliani and Jenna Ellis for evidence to support their claims, Giuliani conceded that even on that late date, "We don't have the evidence, but we have lots of theories." When the legislators were frustrated that Giuliani had no support for his claims and asked him tough questions, Giuliani expressed surprise at the way he was being treated, stating, "Man, I thought we were all Republicans. This is a little more hostile a reception. I'm amazed at the reception I'm getting here." On December 4th, Bowers released a public statement in which he explained that he did not have the authority to use the legislature to reverse the results of the election, and that doing so would constitute an attempt to nullify the people's vote based on unsupported theories of fraud. Bowers made clear that he was disappointed with the legitimate election results because he voted for President Trump and worked hard to re-elect him, but would not violate current law to change the outcome of a certified election. On Twitter, Christina Bobb, a campaign staffer who worked with Boris Epstein, attacked Bowers for his statement, writing that Bowers is intentionally misleading the people of Arizona to avoid the inevitable. The defendant retweeted Christina Bobb's false post and praised her. A month later, just 2 days before January 6th, John Eastman, another of the defendant's private attorneys and a co-conspirator, called Bowers and Bowers Counsel, Person 20, and urged Bowers one last time to use the legislature to decertify Arizona's legitimate electors and overturn the valid election results. When Bowers told Eastman that there was no evidence of substantial fraud in Arizona, and that he could not legally call the legislature into session, Eastman undeterred. He conceded that he didn't know enough about the facts on the ground regarding fraud in Arizona, and said that Bowers should nonetheless falsely claim that he had the authority to convene the legislature and let the courts sort it out. Bowers again refused. In the post-election period, Bowers was harassed. On several occasions, individuals gathered outside Bowers' home with bullhorns and screamed and honked their vehicle horns to create noise. Once, an individual in visible possession of a pistol and wearing a t-shirt in support of a militia group came onto Bowers' property and screamed at him. At the time of these events, Bowers' daughter was at home and was very ill, and the noise caused her disruption and angst.
Two, Georgia.
The defendant had early noticed that his claims of election fraud in Georgia were false. Around mid-November, campaign advisor Jason Miller told the defendant that his claim that a large number of dead people had voted in Georgia was false. The defendant continued to press the claim anyway, including in a press appearance on November 29th, when he suggested that a large enough number of dead voters had cast ballots to change the outcome of the election in Georgia. 4 days later, on December 3rd, Giuliani orchestrated a presentation to a judiciary subcommittee of the Georgia State Senate. In the morning, in advance of it, Giuliani had spoken to the defendant on the phone for almost 20 minutes. And at the hearing, Giuliani arranged for co-conspirators and agents to repeat the false dead voter claim. The claim was so patently false that everyone around the defendant knew it. During the hearing, Chief of Staff Mark Meadows and Eric Hirschman exchanged text messages on their personal phones confirming that a campaign attorney, person 22, had verified that Giuliani's claim of more than 10,000 dead voters was false, and that the actual number was around 12 and could not be outcome determinative. During the subcommittee hearing, the conspirators also set in motion a sensational and dangerous lie about election workers at State Farm Arena that would result in the defendant's supporters harassing and threatening those workers. First, person 23, one of the defendant's private attorneys, claimed that more than 10,000 dead people had voted in Georgia. Next, Jackie Pick, an agent of the defendant, played misleading excerpts of closed-circuit camera footage from State Farm Arena and insinuated that it showed election workers committing misconduct, counting suitcases of illegal ballots. Lastly, based on the false fraud allegations, John Eastman, who had already been engaged as a private lawyer for the defendant, but did not disclose that at the hearing encouraged the Georgia legislators to decertify the state's legitimate electors. While the hearing was ongoing, the defendant simultaneously amplified the misinformation about the State Farm Arena election workers, falsely tweeting, "Wow, blockbuster testimony taking place right now in Georgia. Ballot stuffing by Democrats when Republicans were forced to leave the large counting room. Plenty more coming, but this alone leads to an easy win of the state." He did this just after retweeting 2 of his campaign account's tweets that promoted the false claim about election workers at State Farm Arena. Over the next week, the claim of misconduct at State Farm Arena was disproven publicly, as well as directly to the defendant. The day after the hearing, Gabriel Sterling, the chief operating officer of the Georgia Secretary of State's office, posted a tweet explaining that Secretary of State officers had watched the video in its entirety and confirmed that it showed normal ballot processing. Gabriel Sterling again forcefully debunked the conspirators' claim about the State Farm video in a press conference on December 7th, explaining at length the election workers' innocent conduct depicted in the closed-circuit camera footage and stating,
And what's really frustrating is the president's attorneys had this same videotape. They saw the exact same things the rest of us could see, and they chose to mislead state senators and the public about what was on that video. I'm quite sure that they will not characterize the video if they try to enter it into evidence, because that's the kind of thing that could lead to sanctions, because it is obviously untrue. They knew it was untrue, and they continue to do things like this.
On December 8th, the defendant called Georgia Attorney General Chris Carr. Carr had advance notice that the topic of the call was Texas versus Pennsylvania, an election lawsuit in which Texas was suing other states, including Georgia, to attempt to prevent the certification of election. U.S. Senator David Perdue told Carr that the defendant had heard that Carr was whipping or lobbying other state attorneys general against filing amicus briefs in support of Texas. Carr was not lobbying against the suit and told Perdue so. Perdue asked Carr if he would speak with the defendant about it, and Carr agreed. Shortly thereafter, the defendant called Carr and immediately raised Texas versus Pennsylvania, saying, "I hope you're not talking to your AGs and encouraging them not to get on the lawsuit." Carr told the defendant that he was not affirmatively calling other state attorneys general, but that if they called him, he was telling them what he was seeing in his state, which was something that the defendant probably did not want to hear. Carr was just not seeing evidence of fraud in Georgia. The defendant nonetheless raised various fraud claims. Carr told him that state authorities had investigated the State Farm Arena allegations and found no wrongdoing, and that he thought another claim the defendant raised about Coffee County, Georgia, had been similarly resolved, but would check. The defendant asked Carr to look at them again, because we're running out of time. Carr tried to steer the call to an end by thanking the defendant and telling him that he had voted for him twice and appreciated the defendant, to which the defendant responded, "Yeah, I did a hell of a job, didn't I?" At one point, the defendant raised with Carr the impending runoff election for Georgia's U.S. Senate seats and how important it was to re-elect David Perdue and Kelly Loeffler. The day after the call, the defendant, in his private capacity as a candidate for president, intervened in support of Texas versus Pennsylvania. His attorney, for that matter, was John Eastman. On the same day as the defendant's call with Chris Carr, the defendant's campaign staff acknowledged that the State Farm Arena claim was unsupported, emailing one another about the fact that television networks may decline to run campaign advertisements promoting it. In frustration regarding the claim and others like it, Jason Miller, who spoke with the defendant on a daily basis and had informed him on multiple occasions that various fraud claims were false, wrote, "When our research and campaign legal team can't back up any of the claims made by our elite strike force legal team, you can see why we're 032 on our cases. I'll obviously hustle to help on all fronts, but it's tough to own any of this when it's all just conspiracy shit beamed down from the mothership." On December 10th, however, Giuliani further perpetuated the false State Farm Arena claim when he appeared at another hearing, this one before the Georgia House of Representatives Government Affairs Committee. During it, he displayed some of the same footage as had been used in the December 3rd hearing that had been debunked in the interim by Georgia officials, and nonetheless claimed that it showed voter fraud right in front of people's eyes. He then named 2 election workers, Shay Moss and her mother, Ruby Freeman, and baselessly accused them of quite obviously surreptitiously passing around USB ports as if they are vials of heroin or cocaine, and suggested that they were criminals whose places of work, their homes, should have been searched for evidence of ballots, for evidence of USB ports, for evidence of voter fraud. As these false claims about Freeman and Moss spread, the women were barraged by racist death threats. In the years since, they have spoken about the effect of the defendant and co-conspirators' lies about them. As Ruby Freeman explained in an interview with congressional investigators, when someone as powerful as the President of the United States eggs on a mob, they haven't stopped even today. Indeed, to this day, the defendant has never stopped. That mob will come. They came for us with their cruelty, their threats, their racism, and their hats, falsely attacking Freeman and Moss. Although none of the false claims against them were ever corroborated, the defendant has continued to levy them on social media, including when the defendant attacked Freeman in January 2023, just after her testimony to congressional investigators was made public. Throughout the post-election period, the defendant used Twitter to publicly attack Georgia Governor Brian Kemp with particular aggression. In the 35 days between November 30th, 2020, and January 3rd, 2021, the defendant tweeted critically about Kemp by name or title, more than 40 times. These tweets included the ones also attacking Doug Ducey described above, as well as others particular to Kemp like, "Why won't Governor Ayers Brian Kemp, the hapless governor of Georgia, use his emergency powers, which can be easily done, to overrule his obstinate Secretary of State and do a match of signatures on envelopes? It will be a gold mine of fraud, and we will easily win the state. I will easily and quickly win Georgia if Governor at Brian Kemp, the Secretary of State, permit a simple signature verification. Has not been done and will show large-scale discrepancies. Why are these 2 Republicans saying no? If we win Georgia, everything else falls in place." The Republican governor of Georgia refuses to do signature verification, which would give us an easy win. What's wrong with this guy? What is he hiding? And how does Governor at Brian Kemp allow certification of votes without verifying signatures? And despite the recently released tape of ballots being stuffed, his poll numbers have dropped like a rock. He is finished as governor. In the post-election period, the defendant also made false claims in court about fraud in Georgia unsuccessfully. For example, in Trump versus Kemp, a federal lawsuit in which the defendant sued Georgia's governor and Secretary of State, The defendant signed a verification of fraud allegations that he and his attorney on the case, John Eastman, knew was inaccurate. Eric Hirschman spoke with the defendant and Eastman in late December regarding the proposed verification. First, he told Eastman and another private attorney, Cleta Mitchell, that they could not have the defendant sign it because they could not verify any of the facts. And Hirschman told the defendant that any lawyer that signed the complaint that the verification supported would get disbarred. Eastman acknowledged this problem in an email on December 31st to Kurt Hilbert, lead counsel for the defendant, as candidate in Trump versus Kemp, and another private attorney, writing that in the time since the defendant signed a previous verification in the case, he had been made aware that some of the allegations, and evidence proffered by the experts, has been inaccurate, and that signing a new affirmation with that knowledge and incorporation by reference would not be accurate. Nonetheless, on December 31st, the defendant signed the verification, and Eastman caused it to be filed. On January 2nd, Georgia Secretary of State Raffensperger appeared on Fox News and said that various rumors of election fraud were false, and the defendant had lost in Georgia.
Our office has been very busy with what I call the rumor whack-a-mole. Every day, a rumor will pop up and then we whack it down. What we do is we basically whack it down with the truth. And people can't handle the truth sometimes because they're very disappointed in the results. And I get that. I voted for President Trump also, but at the end of the day, we did everything we could. We did an audit of the race. President Trump still lost. Then we did a full recount. President Trump still lost. We had a safe, secure process.
Raffensperger, like Brian Kemp, had been on the receiving end of the defendant's tweets. These included, "Why isn't the @Georgia Secretary of State Raffensperger, a so-called Republican, allowing us to look at signatures on envelopes for verification? We will find tens of thousands of fraudulent and illegal votes. Rhinos at Brian Kemp at GFF Duncan and Secretary of State Raffensperger will be solely responsible for the potential loss of our two great senators from Georgia, at David Perdue and Kelly Loeffler. Won't call a special session or check for signature verification. People are angry." And, "Georgia, where is signature verification approval? What do you have to lose? Must move quickly. Erv Brian Kemp at Jeff Duncan at Georgia Secretary of State." Shortly after seeing the interview, the defendant set up a call with Raffensperger to discuss his pending private lawsuit, Trump vs. Kemp, in which Raffensperger was a named defendant. For this reason, Raffensperger at first hoped to avoid speaking with the defendant, but ultimately acquiesced because the defendant was persistent in seeking to set it up. Also, because of the pending lawsuit, Raffensperger arranged for his general counsel, Ryan Germany, to participate. Joining the defendant on the call were Chief of Staff Mark Meadows and 3 private attorneys, Kurt Hilbert and Alex Kaufman, counsel of record in Trump vs. Kemp, and the attorneys whom John Eastman had emailed about the defendant's false verification, and Cleta Mitchell, whom Mark Meadows introduced on the call as someone who is not the attorney of record but has been involved. The defendant began the call with an animated monologue in which he argued that he had won the election in Georgia, saying, "Okay, thank you very much. Hello, Raffensperger and Ryan Germany and everybody. We appreciate the time and the call. So we've spent a lot of time on this, and if we could just go over some of the numbers, I think it's pretty clear that we won. We won very substantially, Georgia." Throughout the call, the defendant continued to state that he had won and referenced Biden's margin of victory that he needed to overcome to prevail in the state, including by asserting that, "I just want to find 11,780 votes." He did not reference other elections on the same ballot. After the defendant's opening salvo, Raffensperger stated, "Well, I listened to what the president has just said. President Trump, we've had several lawsuits, and we've had to respond in court to the lawsuits and the contentions. We don't agree that you have won." The defendant raised multiple false claims of election fraud, each of which Raffensperger refuted in turn. When the defendant attacked Ruby Freeman, called her a professional vote scammer and hustler, and mentioned her dozens of times throughout the call, Raffensperger said, "You're talking about the State Farm video, and I think it's extremely unfortunate that Giuliani or his people, they sliced and diced that video and took it out of context. He then offered the defendant a link to a video disproving the claim, to which the defendant responded, "I don't care about a link, I don't need it. I have a much better link." When the defendant claimed that 5,000 dead people had voted in Georgia, Raffensperger said, "Well, Mr. President, the challenge you have is the data you have is wrong. The actual number were two people that were dead that voted. And so that's wrong. That was 2. When the defendant claimed that thousands of out-of-state voters had cast ballots, Raffensperger counsel, Ryan Germany, responded, "We've been going through each of those as well, and those numbers that we got, that Ms. Cleta Mitchell was just saying, they're not accurate." At one point, the defendant became frustrated after both Raffensperger and Ryan Germany explained repeatedly that his claims had been investigated and were not true, and stated, "And you're gonna find that they are, which is totally illegal. It's more illegal for you than it is for them because you know what they did and you're not reporting it. That's a criminal. That's a criminal offense. And, you can't let that happen. That's a big risk to you and to Germany, your lawyer. That's a big risk." The call ended with Germany stating that he would coordinate with the lawyer representing Raffensperger office in the private lawsuit and get together with Kurt Hilbert, as agreed earlier in the call. The day after the call, on January 3rd, the defendant falsely tweeted, "I spoke to Secretary of State Raffensperger yesterday about Fulton County and voter fraud in Georgia. He was unwilling or unable to answer questions such as the ballots under table scam, ballot destruction, out-of-state voters, dead voters, and more. He has no clue." Raffensperger promptly responded in a tweet of his own, "Respectfully, President Trump, what you're saying is not true. The truth will come out."
Three, Michigan.
On November 20th, 3 days before Michigan's governor signed a certificate of ascertainment appointing Biden's electors based on the popular vote, the defendant met with Mike Shirkey and Lee Chatfield, Michigan's Senate Majority Leader and Speaker of the House, at the Oval Office. The defendant initiated the meeting by asking RNC Chairwoman Ronna McDaniel to reach out to Chatfield and gauge his receptivity to a meeting. The defendant also asked McDaniel to participate in the meeting, but McDaniel told him that she had consulted with her attorney and that she could not be involved in a meeting with legislators because it could be perceived as lobbying. After McDaniel made the first contact, on November 18th, the defendant reached out to Shirkey and Chatfield to extend an invitation. The same day that he contacted Shirkey and Chatfield, the defendant issued a false tweet. "In Detroit, there are far more votes than people. Nothing can be done to cure that giant scam. I win Michigan." When the defendant called Shirkey and Chatfield to invite them to the White House, he did not provide the topic of the meeting, but he did ask about allegations of fraud in the election in Michigan. The legislators told him that they and the Michigan legislature were examining the allegations. Both Shirkey and Chatfield assumed that the defendant wanted to see them to discuss claims of election fraud, and they wanted to be firm that they had not seen evidence that would change the outcome of the election. For this reason, and to avoid talking only about election fraud, they prepared materials to raise regarding COVID-19 and planned in advance to release a statement once the meeting was over that said that the legislators were unaware of information that would change the outcome of the election. Over the course of the meeting, the defendant dialed in both Ronna McDaniel despite her request not to participate, and Giuliani. Mark Meadows was present for some, but not all, of the meeting. After some small talk with the legislators in the Oval Office, the defendant raised various fraud claims, including that he had lost Michigan because of fraud or misconduct in Wayne County, where Detroit is located. Mike Shirkey corrected the defendant and told him that he had lost primarily because in 2 routinely Republican counties, the defendant had underperformed with educated females, and if he had received the same number of votes there as the 2 winning local sheriffs, he likely would have won Michigan. Mike Shirkey could tell by the defendant's body language that he was not happy to hear Shirkey's assessment. Notably, the defendant only raised fraud claims to the extent that they affected the outcome in his own race, not those for other offices in Michigan. Giuliani participation came after the legislators assured the defendant that they were looking into fraud claims. The defendant dialed Giuliani into the meeting and said, "Giuliani, tell them what's going on." Giuliani then launched into a fraud monologue. Finally, Shirky interrupted and asked, "So when are you going to file a lawsuit in Michigan?" A question that Giuliani ignored and did not answer. Immediately after the meeting, Shirky and Lee Chatfield released a public statement in which they stated that they had not yet been made aware of any information that would change the outcome of the election in Michigan. On November 21st, the defendant acknowledged Shirky and Chatfield's statement when he tweeted, "This is true but much different than reported by the media," and implicitly conceded that he had not provided evidence of fraud yet when he added, "We will show massive and unprecedented fraud." Days later, the defendant's campaign declined to request a statewide recount in Michigan, for which it would have had to pay unless the recount succeeded in changing the outcome of the election. Immediately after the meeting, Mike Shirky and Lee Chatfield released a public statement in which they stated that they had not yet been made aware of any information that would change the outcome of the election in Michigan. On November 21st, the defendant acknowledged Shirky and Chatfield's statement when he tweeted, "This is true, but much different than reported by the media," and implicitly conceded that he had not provided evidence of fraud yet when he added, "We will show massive and unprecedented fraud." Days later, the defendant's campaign declined to request a statewide recount in Michigan, for which it would have had to pay unless the recount succeeded in changing the outcome of the election. Despite failing to establish any valid fraud claims, Giuliani followed up with Shirky and Chatfield and attempted to pressure them to use the Michigan legislature to overturn the valid election results. On December 4th, Giuliani sent a message to Chatfield claiming that Georgia was poised to do so, based on Giuliani's and John Eastman's false advocacy there in the December 3rd hearing, and asked Chatfield for help. Looks like Georgia may well hold some factual hearings and change the certification under Article 2, Section 1, Clause 2 of the Constitution. As Eastman explained, they don't just have the right to do it, but the obligation. Help me get this done in Michigan. On December 7th, Giuliani attempted to send Shirky a message, though failed because he typed the wrong number into his phone. "So I need you to pass a joint resolution from the Michigan legislature that states that the election is in dispute. There's an ongoing investigation by the legislature, and the electors sent by Governor Whitmer are not the official electors of the state of Michigan and do not fall within the safe harbor deadline of December 8th under Michigan law." Campaign operative Mike Roman was involved in the drafting of this message with the assistance of Person 41, who was associated with the defendant's campaign efforts in Michigan. The following day, Giuliani shared the draft with the defendant, sending it to his executive assistant, Molly Michael, by email. These efforts failed. On December 14th, the day that duly appointed electors across the country met and cast their electoral votes, Shirky and Chatfield issued public statements confirming that the defendant had lost Michigan, and the legislators still had not received evidence of outcome-determinative fraud in their state. Mike Shirky's public statement included, "We have not received evidence of fraud on a scale that would change the outcome of the election in Michigan." Lee Chatfield stated, in part,
"We've diligently examined these reports of fraud to the best of our ability. Fought hard for President Trump. Nobody wanted him to win more than me. I think he's done an incredible job. But I love our republic, too. I can't fathom risking our norms, traditions, and institutions to pass a resolution retroactively changing the electors for Trump, simply because some think there may have been enough widespread fraud to give him the win. That's unprecedented for good reason. And that's why there is not enough support in the House to cast a new slate of electors. I fear we'd lose our country forever. This truly would bring mutually assured destruction for every future election in regards to the Electoral College. And I can't stand for that. I won't."
On January 3rd, the defendant's campaign publicly posted Mike Shirky's phone number and attempted to post Lee Chatfield's, but erred by one digit, in a tweet urging, "Contact Speaker Lee Chatfield and Senate Majority Leader Mike Shirky." Mike Shirkey received 4,000 text messages in 2 hours, forcing him to get a new phone number.
4. Nevada.
On November 17th in Law v. Whitmer, agents of the defendant in Nevada filed suit claiming substantial irregularities, improprieties, and fraud in the presidential election, including based on machines used in ballot signature matching and votes by non-resident and dead voters. The defendant approved a press conference by his surrogates announcing the suit. On November 19th, Justin Reamer, the RNC chief counsel, sent an email to Liz Harrington, an RNC spokesperson, warning about inaccuracies in the suit. Just FYI that I don't believe the claims in the contest regarding dead voters, those voting from out of state, etc., are substantiated. We are working with the campaign on a data matching project, and those numbers are going to be a lot lower than what the NV people have come up with. They are also targeting our military voters. To be frank, the contest has little chance of succeeding. Happy to discuss this stuff if you want more info. Harrington then sent a copy of Reamer's email from her personal email account to the personal email account of Dan Scavino, one of the defendant's White House staffers who also volunteered for the campaign. Notwithstanding the RNC chief counsel's warning, the defendant retweeted and amplified news of the lawsuit on November 24th, calling it big news, that a Nevada court had agreed to hear it. But the defendant did not similarly promote the fact that within 2 weeks, on December 4th, the Nevada District Court dismissed Law v. Whitmer, finding in a detailed opinion that there is no credible or reliable evidence that the 2020 general election in Nevada was affected by fraud, including through the signature match machines, and that Biden won the election in the state. 4 days later, on December 8th, Nevada's Supreme Court unanimously affirmed the district court's decision, noting that despite its earlier order asking appellants to identify specific findings with which they take issue, appellants have not pointed to any unsupported factual findings, and we have identified none. Later, in his ellipse speech on January 6th, the defendant repeated multiple claims explicitly rejected by Nevada courts. On December 18th, the Nevada Secretary of State's office released a facts versus myths document to combat disinformation that the defendant and others were propagating about the election, including false claims that the Secretary of State's office had not investigated claims of fraud, even though it had been presented with evidence of widespread fraud, to which the office responded, "While we are pursuing action in a number of isolated cases, we have yet to see any evidence of widespread fraud." The Facts versus Myths document also stated publicly that courts had universally rejected fraud claims. 4 separate cases were heard by Nevada judges, including the Nevada Supreme Court. After examining records presented, each case was discounted due to a lack of evidence.
5. Pennsylvania.
2 days after the election, on November 6th, the defendant called Lawrence Tabas, the chairman of the Pennsylvania Republican Party, the entity responsible for supporting Republican candidates in the Commonwealth at the federal, state, and local level. Tabas had a prior relationship with the defendant, including having represented him in litigation in Pennsylvania after the 2016 presidential election. The defendant asked Tabas how, without fraud, he had gone from winning Pennsylvania on Election Day to trailing in the days afterward. Consistent with what campaign staff already had told the defendant, Tabas confirmed that it was not fraud. It was that there were roughly 1,750,000 mail-in ballots still being counted in Pennsylvania, which were expected to be 80% for Biden. Over the following 2 months, the defendant spread false claims of fraud in Pennsylvania anyway. In early November, in a campaign meeting, when the defendant suggested that more people in Pennsylvania voted than had checked in to vote, Deputy Campaign Manager Justin Clark corrected him. Around the same time, Philadelphia City Commissioner A.L. Schmidt appeared on television and stated that there was no evidence of widespread fraud in Philadelphia. After seeing the interview, the defendant targeted Schmidt, tweeting, "A guy named A.L. Schmidt, a Philadelphia commissioner and so-called Republican, Rhino, is being used big time by the fake news media to explain how honest things were with respect to the election in Philadelphia. He refuses to look at a mountain of corruption and dishonesty. We win. As a result of the defendant's attack, threats that Schmidt already was receiving became more targeted and detailed, and included his address and the names of his family members. On the defendant's behalf, Giuliani too spread patently false claims about Pennsylvania. On November 25th, Giuliani and Jenna Ellis attended an unofficial hearing with Republican state legislators in a Gettysburg Hotel conference room. The defendant called in, claimed to have been watching, and demanded that the election in Pennsylvania has to be turned around. During the event, Giuliani falsely stated that Pennsylvania issued 1.8 million absentee ballots and received 2.5 million in return. The claim was rooted in an obvious error, the comparison of the number of ballots sent out in the primary election to the number of ballots received in the general election. After seeing Giuliani make this claim, Justin Reimer, the RNC's chief counsel, tweeted publicly, "This is not true." In the following days, campaign staff internally confirmed that Giuliani was lying. When one campaign staffer wrote in an email that Giuliani claim was just wrong, "And there's no way to defend it," Clark responded. "We have been saying this for a while. It's very frustrating." Likewise, in late November or December, Eric Hirschman informed the defendant directly that a claim Giuliani was spreading, that Pennsylvania received 700,000 more mail-in ballots than were mailed out, was bullshit, and explained the error. Justin Reimer followed up on his public tweet in a private email on November 28th to Liz Harrington, the RNC spokesperson, expressing his concern about Giuliani and Jenna Ellis' spread of disinformation. "I'm really not trying to give you a hard time, but what Giuliani and Ellis are doing is a joke, and they are getting laughed out of court. It's setting us back in our fight for election integrity, and they are misleading millions of people who have wishful thinking that the president is going to somehow win this thing." When Giuliani learned of Reimer tweet and email on November 28th, he called Justin Reimer and left a threatening voicemail stating, "I really do need an explanation for what you said today, because if there isn't a good one, you should resign. Got it? So call me or I'll call the boss and get you to resign. Call me. It'd be better for you if you do." Giuliani also contacted RNC chairwoman Ronna McDaniel to demand that Reimer be fired, and thereafter Reimer relieved of his duties as RNC chief counsel. On December 3rd, 4 Republican leaders of the Pennsylvania legislature issued a public letter stating that the General Assembly lacked the authority to overturn the popular vote and appoint its own slate of electors, and that doing so would violate the state election code and constitution. Bernie Carrick, an agent of the defendant who worked closely with Giuliani, issued a tweet showing the 4 legislators' names and signatures and wrote, "These are the 4 cowardice Pennsylvania legislators that intend to allow the Democrat machine to hashtags steal the vote. Cowards, liars, traitors," while linking to the legislators' Twitter accounts. On Sunday, December 6th, at 12:56 a.m., from the White House residence having just returned from a political rally in Valdosta, Georgia, the defendant retweeted and amplified Carrick's post.
6. Wisconsin.
On November 29th, a recount that the defendant's campaign had petitioned and paid for confirmed that Biden had won in Wisconsin and increased the defendant's margin of defeat. On December 14th, the Wisconsin Supreme Court rejected the campaign's election lawsuit there. As a result, on December 21st, Wisconsin's governor signed a certificate of final determination, confirming the prior certificate of ascertainment that established Biden's electors as the valid electors for the state. In response, the defendant issued a series of tweets attacking Brian Hagedorn, the Wisconsin Supreme Court justice, who had written the majority opinion rejecting his campaign's lawsuit and advocating that the Wisconsin legislature overturn the valid election results.
2 years ago, the great people of Wisconsin asked me to endorse a man named Brian Hagedorn for state Supreme Court justice when he was getting destroyed in the polls against a tough Democrat candidate who had no chance of losing. After my endorsement, Hagedorn easily won. Wow. He just voted against me in a big court decision on voter fraud, of which there was much, despite many pages of dissent from 3 highly respected justices. One thing has nothing to do with another, but we ended up losing 4-3 in a really incorrect ruling. Great. Republicans in Wisconsin should take these 3 strong decisions to their state legislators and overturn this ridiculous state election. We won in a landslide.
After the defendant's tweet, the state marshals responsible for Hagedorn's safety arranged to provide Hagedorn with additional police protection based on social media traffic and other threatening communications.
Seven, voting machines in multiple states.
Throughout the post-election period, the defendant and co-conspirators repeatedly made claims about the security and accuracy of voting machines across multiple states, despite the fact that they were on notice that the claims were false. As early as November 12th, for instance, the National Association of Secretaries of State, the National Association of State Election Directors, and other coordinated federal, state, and private entities issued a public statement declaring that the 2020 election was the most secure in American history, and that there was no evidence that any voting system deleted or lost votes, changed votes, or was in any way compromised. On November 14th, in the tweet announcing that Giuliani was to lead his campaign legal efforts, the defendant also named Sidney Powell, a private attorney who was fixated on voting machine claims, and Joseph DiGenova, another private attorney. 2 days later, on November 16th, on the defendant's behalf, Executive Assistant Molly Michael sent Sidney Powell and other private attorneys an email titled "From POTUS," attaching a document containing bullet points critical of Dominion Voting, a company that manufactured voting machines used in certain states, and writing, "See attached. Please include as is, or almost as is, in lawsuit." Powell responded 9 minutes later, writing, "It must go in all suits in Guy and Pa immediately with a fraud claim that requires the entire election to be set aside in those states and machines impounded for non-partisan professional inspection." On November 17th, Chris Krebs, the director of the Department of Homeland Security's Cybersecurity and Infrastructure Security Agency, CISA, publicly tweeted that a group of private election security experts concluded that claims of computer-based election fraud either have been unsubstantiated or are technically incoherent. 2 days later, on November 19th, Giuliani, Sidney Powell, Joseph DiGenova, and others held a press conference at the RNC headquarters on behalf of the defendant and his campaign. During it, Powell made false and factually impossible claims regarding Dominion voting and the integrity of the country's election infrastructure. That night, Fox News television personality Tucker Carlson stated on air that because of Sidney Powell's incendiary comments about voting machines, he had invited her on his television program. He further stated, "But she never sent us any evidence despite a lot of requests, polite requests. Not a page. When we kept pressing, she got angry and told us to stop contacting her. When we checked with others around the Trump campaign, people in positions of authority, they told us Sidney Powell has never given them any evidence either. She never demonstrated that a single actual vote was moved illegitimately by software from one candidate to another. Not one." The defendant saw his private attorney's RNC press conference and Tucker Carlson's discussion of Sidney Powell, and he acknowledged to Jason Miller that Powell had appeared unhinged in the press conference. On November 20th, the day after the press conference, the defendant made a similar comment to Person 7 and Dan Scavino, 2 White House staffers who also volunteered for his campaign. In casual conversation after another meeting had ended, the defendant told Person 7 and Dan Scavino that Carlson had eviscerated, or destroyed, Powell. The defendant then had a call with Powell on speakerphone, while in Person 7 and Dan Scavino listened in, and mentioned the Carlson segment to Powell. While Powell responded, the defendant placed the call on mute and to Person 7, and Dan Scavino mocked and laughed at Powell called her claims crazy, and made a reference to the science fiction series Star Trek when describing her allegations. In the same time period, when Eric Hirschman told the defendant that Powell claims were unreliable and should not be included in lawsuits, the defendant agreed that he had not seen anything to substantiate Powell allegations. On November 22nd, notwithstanding the defendant's tweet from 8 days prior announcing Powell's involvement, Giuliani issued a statement on behalf of the campaign distancing the defendant from Powell. Sidney Powell is practicing law on her own. She is not a member of the Trump legal team. She is also not a lawyer for the president in his personal capacity. Nonetheless, the defendant continued to support and publicize Powell knowingly false claims. For example, within days of Giuliani's statement, the defendant promoted a lawsuit that Powell was about to file, tweeting on November 24th, "Breaking news. Sidney Powell says her lawsuit in Georgia could be filed as soon as tomorrow and says there's no way there was anything but widespread election fraud. #MAGA, #America First, #Dobbs." Powell filed a lawsuit the next day against the governor of Georgia, falsely alleging massive election fraud, accomplished through Dominion voting election software and hardware. The defendant again promoted the lawsuit in a tweet. The lawsuit was dismissed within 2 weeks, on December 7th. On November 29th, Chris Krebs, who was no longer the CISA director, appeared on the television program 60 Minutes. Krebs stated that he was confident that the election had been secure and that there was no manipulation of the vote on the machine count side. In response, the defendant tweeted publicly about Krebs' appearance. 60 Minutes never asked us for a comment about their ridiculous one-sided story on election security, which is an international joke. Our 2020 election, from poorly rated Dominion voting to a country flooded with unaccounted for mail-in ballots, was probably our least secure ever. A few days later, Joseph DiGenova appeared on a radio program as the defendant's agent and said that because of Krebs' comments to promote confidence in the security of the election infrastructure, Krebs should be drawn and quartered, taken out at dawn and shot. Thereafter, Krebs was subjected to death threats. In a press conference on December 1st that the defendant acknowledged watching, Gabriel Sterling, a Georgia election official, decried DiGenova and the defendant's public statements spreading disinformation and said that if they did not stop, someone is going to get killed. On December 1st, Attorney General William Barr stated publicly that the Justice Department had not seen evidence of fraud sufficient to change the election results. With respect to voting machines, he said, "There's been one assertion that would be systemic fraud, and that would be the claim that machines were programmed essentially to skew the election results. And the DHS and DOJ have looked into that, and so far we haven't seen anything to substantiate that." Giuliani and Jenna Ellis immediately issued a formal campaign statement attacking Barr and the Justice Department, writing, "With all due respect to the Attorney General, there hasn't been any semblance of a Department of Justice investigation. His opinion appears to be without any knowledge or investigation of the substantial irregularities and evidence of systemic fraud." In mid-December, the defendant spoke with RNC chairwoman Ronna McDaniel and asked her to publicize and promote a private report that had been released on December 13th that purported to identify flaws in the use of Dominion voting machines in Antrim County, Michigan. Ronna McDaniel refused, telling the defendant that she already had discussed the report with Lee Chatfield, Michigan's Speaker of the House, who had told her that the report was inaccurate. McDaniel conveyed to the defendant Chatfield exact assessment. The report was fucking nuts. On January 2nd, during the defendant's call with Georgia Secretary of State, Raffensperger said of false claims regarding voting machines, "I don't believe that you're really questioning the Dominion voting machines. Because we did a hand retally, a 100% retally of all the ballots, and compared them to what the machine said and came up with virtually the same result. Then we did the recount, and we got virtually the same result. So I guess we can probably take that off the table." In response, the defendant falsely claimed that in other states, "We think we found tremendous corruption with Dominion voting machines, but we'll have to see." At the Ellipse on January 6th, the defendant and co-conspirators who spoke at the rally continued to make unsubstantiated and false claims about Dominion voting machines. Giuliani claimed that in the U.S. Senate runoff election in Georgia the day before, the votes were deliberately changed by the same algorithm that was used in cheating President Trump and Vice President Pence. John Eastman continued the false attack. "We now know, because we caught it live last time in real time, how the machines contributed to that fraud. They put those ballots in a secret folder in the machine sitting there waiting, until they know how many they need. And then the machine, after the close of polls, we now know who's voted. And we know who hasn't. And I can now, in that machine, match those unvoted ballots with an unvoted voter and put them together in the machine. We saw it happen in real time last night, and it happened on November 3rd as well. In his own speech, the defendant again raised the false specter of the highly troubling matter of Dominion voting, and lied about machines flipping votes from the defendant to Biden and an astronomical and astounding error rate in the machine's ballot scanning.
Thank you for listening to this special NatSecMedia presentation, a reading from the United States versus Donald Trump criminal case. Subscribe below so you can be notified of our next segment and future articles. Next time we will explore Section D. The defendant organized and caused his electors to submit fraudulent certificates, creating the false appearance that states submitted competing electoral slates. NatSecMedia is non-commercial programming, supported by listeners and viewers like you. Subscribe below to stay tuned to our next video. Consider subscribing on Patreon at NatSecMedia. Thank you.